Hi everyone, and welcome back to, again, this is Business Law. This is week 6. This is going to be, we're discussing chapter 10, enforceability. Now again, this is the week 6, but this is the third video on still dealing with contracts. This third out of the 4, so next week we'll still do another contract one, but I think next week is chapter 11. But this week, this video focusing on chapter 10, the enforceability. Again, the PowerPoint is posted on Blackboard. If you want to check it out and follow along, that'd be great. And then again, I know I mention this all the time, but I just gotta say my speech again. It'd be great if you read the chapter 10 before this. I think reading chapter 10 and then following along with the presentation with the PowerPoint, you'll really be able to understand the subject matter much better than as opposed to you're just kind of just jumping on and seeing the video and following along with the PowerPoint. So if you do get a chance, if you can go ahead and read chapter 10 and then watch the video, I think that's a great way for you to really understand the subject matter that we're talking about. Okay, again, PowerPoints are should be on Blackboard by the time you see this. So if you have any questions, you guys know how to reach me. But let's get started and jump on onto the first slide. Thank you. Now jumping on to slide number 2, the chapter learning objectives here. There are 6 of them, so I'm just going to go through them. But after studying this chapter, you should have been able to at least know or understand these 6 concepts. Concept 1, define the contract doctrine of enforceability. And what I mean by that is how to enforce a contract, meaning if there's one party who is in breach or in default and not following what the contract says, how does the person who is still following the contract, how do they enforce the contract on the other person who is not in compliance with their contract? Second, identify the 5 steps of consent defects, situations in which genuine assent to a contract where it may be lacking. Understand the strategic concept of asystematic information and distinguish between innocent misrepresentations and fraudulent misrepresentations in contracts. We're also going to apply the contract defenses. One of them, first defense, we're going to talk about duress. Then we're going to talk about undue influence. And then third, we're going to talk about unconscionability. So we'll talk about those 3 contract defenses. We're going to also articulate when contracts must be in writing under the statute of frauds doctrine. If you don't know what that doctrine is, as we'll move along, we'll understand that. And then 6, and the final point that I want to cover in this one is we're going to explain how the courts, how they use the parole evidence rule to interpret contracts. Again, these 6 things, hopefully after this video, you'll at least be able to understand with these 6 concepts, what they mean, and kind of be able to understand them, perhaps maybe apply them one day to your career or to your circumstances. Hopefully this video goes well with you guys. But okay, let's jump into to the next slide so we can talk about these things. And we're jumping into slide number 3. Now, some of these concepts, some of these points, I know some people may say, well, yeah, well, of course, that's obvious, but I just want to make sure I do put as much as I can into these PowerPoints to make sure you get as much material or meat in the PowerPoints as possible. Jumping into slide number 3, the enforceability of contracts. Now, if the parties have formed a valid contract, the legal analysis now it turns into the enforceability of that agreement or to that contract. A contract, it's of little use or of little value if it's not enforceable in a court. If one party signs an agreement with another party and all the elements are met, but if we can't go to court and sue on it or have that contract be enforced on the other party, then why sign the contract in the first place, right? So business firms or even individuals or companies, they have to ensure that their contracts are not only properly formed, but also enforceable, because they want to make sure the other party's not doing what they say. Then they're going to take them to court and hopefully win on that breach of contract and maybe even have damages, meaning I'm suing for a certain amount of money because you did not fulfill your contract. Now, even if all the required elements of a contract are met, That's agreement, consideration, capacity, and a lawful purpose, legality. Those 4 elements we discussed in the prior 2 videos. So if you don't remember them, go ahead and you can watch the other 2 videos or look at the PowerPoints. But that's the agreement, consideration, capacity, and legality. Those 4 are the 4 elements of a contract. So even if all those are present and have been met, the contract must be the product of a genuine assent. And it must be in writing. In certain circumstances, the contract has to be in writing, or else it is not enforceable. So there are certain situations where it must be in writing, or else the agreement, even if you have all of that, we agreed it won't be enforceable because it's not in writing. So let's jump on the next slide and keep going to talk about these things. Now going on here into slide number 4, the consent defects. Now there are 5 situations when a genuine assent may be lacking. Now the first one we're gonna go over the all of these in the next slides, but the first one is going to be misrepresentation. The second one will be fraud. The third one, duress. The fourth one, undue influence. And then the fifth one, unconscious ability. Now if one of these 5 consents defects are present, then they cannot be any or there will not be any genuine assent. Now, and the contract may not be enforceable because there is a defect, a consent defect in the contract, and therefore, I mean, if you're a company, you want to make sure it's enforceable. So you have to make sure that none of these 5 defects are present, because then you may abide, you may do everything you can in the contract. It may be one-sided. However, if there's a defect, then it's not enforceable. So you won't be able to present it in court and have a judge rule against you and against the other guy, and therefore make the other guy, or award you damages that the other guy has to pay you. So we have to make sure, although the contract meets all the 4 elements, there cannot be any defects to the contract, because if there's defects, then it will not be enforceable. Okay, well let's go on the next slide and we can go over these 5 defects in a little more detail so we can really understand them. Now we're going to jump into slide number 5, and let's talk about the first one of these 5 defects. Now the first one is going to be misrepresentation. Now a misrepresentation occurs when one party to an agreement makes a promise or representation about a material fact that is just not true, that is just a lie. Now most of the contracts here, we understand that when someone goes into a contract, perhaps maybe one party has more information than the other and puts them in a better bargaining position or a business or a position to have a better deal toward for that person, and that's fine if they have that information, and maybe one party didn't do enough research, so therefore they have a couple more ammunitions in their pocket, or basically information. So that's okay. But what we're talking about here is misrepresentation of something that they believe to be true. Now, the common law, the courts here, they recognize 2 types of misrepresentation. The first one is going to be innocent misrepresentations, and the second one, the more important one, is going to be fraudulent misrepresentations. Now, most courts recognize these 2, so it's very important to know that this defect of a misrepresentation of a material fact. So a material fact is going to be something that is very important about the deal. We can't just a misrepresentation or a lie about just a fact that doesn't mean anything in the contract or doesn't affect it. Perhaps maybe that's not a misrepresentation. That's just maybe a lie, or you misidentified a topic, or you inflated it to look better. That's different than a material fact. A material fact is the terms that really make or break a contract. Something that one party could say, well, this material fact, if that wasn't the truth, then I wouldn't get to that. I wouldn't do the deal, because that's a very, very important fact to the contract. So it has to be a material fact that is the misrepresentation. Let's go over the next slide. We'll talk about the 2 misrepresentations, which are the innocent misrepresentation and the fraudulent misrepresentation. All right, let's jump to the next slide. Now getting on here to slide number 6, the innocent misrepresentation. Now an innocent misrepresentation can occur even if the the misrepresenting party, the person who's saying the incorrect statement, he doesn't actually know that the promise or misrepresentation is false. Now, for example, if you're buying, buying my house, and I tell you, hey, you want to buy my house, and you ask me, what condition is the roof in? I may say the roof is in great condition. I mean, I may believe that. I may honestly believe that the roof is in great condition, even though it's not. I'm not a roofer, so perhaps maybe a professional roofer may say, no, that roof is in horrible condition. I was saying the misrepresentation, but it's an innocent misrepresentation that I had no idea, that I truly believed. I did believe the roof was innocent. So therefore, I would be the innocent the party doing an innocent misrepresentation. Now, for a party to avoid a contract based on an innocent misrepresentation, he or she must prove that three things: that the misrepresentation was material, it was a very important part of the contract, that that person justifiably relied on the misstatement. So I relied on the misstatement when forming the agreement, and the misrepresentation was one of fact, that not just one's opinion, but it was mere puffering. That those are the three statements or items that need to be in the facts to be able to fall back and try to make the contract unenforceable due to an innocent misrepresentation. Now, again, it has to be a material fact. Now, for example, if somebody says the same roof example and say, I think my roof is in great condition, and it's not, that would fall under, again, the innocent misrepresentation. Now, to go on the other side, a fraudulent misrepresentation would be more of same scenario. I want to sell you my house. You ask me, how's my roof? If I knew my roof was 20 years old and I told you, yeah, it's in great condition, it's only 3 years old. At that point, that's not an innocent misrepresentation, because I can't really, it's a numbers game. I can't pretend to say it's 3 years old when it's really 20. So if I say it's in great condition, that may be an innocent misrepresentation. But if I say, it's in great condition, it's 3 years old, the fact of me saying it's 3 years old when I know it's 20, that is not an innocent misrepresentation, and that falls more under just plain fraud, or fraudulent misrepresentation. So which is a lot heavier for me to kind of swoop aside and say, oh, well, no, that was just a little misrepresentation. No, that was a fraudulent misrepresentation of a material fact, because that's something that the buyer definitely would have considered, or maybe at least maybe even said, no, they don't want to buy my property because the roof is too old or something like that. But a fraudulent misrepresentation those are easy to spot, because it's very clear that there's no wiggle room in trying to justify why the person said that. So that's just wanted to get a little touching on the innocent misrepresentation. I know I have the PowerPoint on the innocent misrepresentation, but I don't have one on a fraudulent one. But kind of giving you that roof example of the 20-year-old, and I say it's 3 years old, you guys can understand why fraudulent misrepresentation is easier to spot. Okay, well let's jump on to the next slide. Now I'm jumping on here to slide number 7. I know I previously just mentioned that when doing the video of innocent misrepresentation, I decided, I said there that we didn't need the fraudulent misrepresentation, but then I thought about it and said, you know what, I'm going to put this slide on there just so they have it and they can see a little bit more. I didn't want to just you guys assuming or trying to guess what that was. But in the fraudulent misrepresentation, or just plain fraud, when one party has engaged in conduct that the standard of the misrepresentation, the individual has actual knowledge, then for that misrepresentation being false, that is a fraudulent misrepresentation. So again, same example, if I tell you the material fact, hey, you want to buy my house, if I know the roof is 20 years old, and you ask me, oh, you know what, I want to buy a house, but the last house I bought, I had a lot of problems with the roof, so I want to buy, a good young roof. And I tell you, knowing that my roof is 20 years old, and then I tell you, hey, the roof it's in great shape. Now that's just opinion. That's going to be hard to hold me to that. But if I say it's in great shape, and it's only 3 years old, then at that point, that's when it's a fraudulent misrepresentation. I think we just discussed this, but that's also known as plain fraud. Now, the misrepresentation plus the guilty knowledge equals the fraudulent misrepresentation. So the misrepresentation, it's the actual fact plus me knowing that the fact is a lie. Then that combined is the fraudulent misrepresentation. Now, in cases of fraudulent misrepresentation, most cases or most courts are going to classify that contract as it's a void contract, and the victim, I would call him the victim, but the aggravated party in that contract is generally entitled to, they're going to recover monetary damages. So they're going to recover their actual money that they spent or that they lost or that they could have gotten or used, actual expenses for any of the losses incurred, plus actual damages, plus additional damages, which may include loss of future profits, which the court obviously and any party's going to have to show that through evidence and things like that. But they're going to maybe show lost profits for 1 year, 2 year, 3 year, but they're going to try to extend as much the lost profits as much as possible to make sure to get as much as possible from that from the fraudster or from the individual who created the fraudulent misrepresentation. Now, some states, they're going to go as far as to allow what is called treble damages. Now, they're going to give you 3 times the amount of actual damages. So, say you bought a house, just a quick example, you bought a house for $100,000, and there was a fraudulent misrepresentation. You thought the roof was in great condition. He told you, or seller told you, it was only 3 years old. Something happens, there's a bunch of roof damage, and everything inside gets damaged as well, something very valuable. Then at that point, you accumulate, you present what was actually harmed. I want a new roof. All these things inside my house were damages. Now, whatever the amount of damages were, some courts will give you 3 times that amount if you can prove that there were the actual damages and the individual who sold it to you committed a fraudulent misrepresentation, meaning a material fact. He lied about a material fact and he knew it was a lie. So just be sure that you know that. And the treble damages is 3 times damages is a big thing for someone to get, as well as attorneys when they know the possibility. If someone is representing the individual who got harmed, most attorneys know, hey, we can go, in some states we can go after for treble damages 3 times as much. So let's go for it so we can try to get as much as possible. So it's very important to know that being a fraud in contract, and it will most of the time always come back and get you, and you will pay for it, maybe even 3 times as much. But let's go into next slide and keep discussing this. Now, jumping on here to slide number 8 is a table of innocent misrepresentation versus fraudulent misrepresentation, or we'll just call it pure fraud. The innocent mistake versus the fraudster, the fraud. Now we're going to go discuss some of the differences. We'll just go from side to side now. In misrepresentation, now the person making the representation or the statement believes it to be true. Again, if someone said, I'm just giving you an example of, if I'm selling you my house and I truly believe the roof to be okay, then I may tell you, okay, yeah, you may ask me, how's the roof? I say, I think it's in great condition. If it's never leaked on me, it may be old and it may already need to be replaced, but perhaps maybe if the roof has never leaked, I may think it's in great condition. I didn't go up there to see it, but it's never leaked on me, so it's in great condition. Even though it's not in great condition, I still believe that to be true. So that's going to still fall under the innocent misrepresentation. Now, also, for it to be a misrepresentation or an innocent misrepresentation, the party saying this statement, where in my example would be me, there's no intention to deceive the other party or to trick the other party in that case. I'm just honestly thinking it's my opinion. I truly believe the roof is in great condition, and I'm telling you that. So there's no intention to trick you. That's my honest opinion. Now, what the party can do, the party receiving the information, the party receiving, let's say we signed the contract to buy it, and the person goes up there and has a roof inspector go up there, and the roof says, no, this roof is not in good condition. It's old, and it's about to, for instance, I know it's a big example, or an exaggerated example, but it's about to collapse. The roof if there's a heavy rain, that roof is going to fall in. Okay, so That's obviously different than my statement. My statement was, I think it's a great roof. It's never leaked on me, so therefore I at least have justification to say it's a great roof. But if you go up there, you find out that it's, you know, far from being a great roof, a complete 180, then you, as the party who I said that misrepresentation, you have the right to avoid the contract, cancel the contract for that matter. However, there's nothing else. You can't go after me for damages. You can just get out of the contract and say, Robert, your statement was completely incorrect, or your opinion was completely incorrect. Therefore, I'm just going to walk away from the contract. And as the other party, that's their right. Now, shifting to the other side, the fraudulent misrepresentation or the fraud. Now, the person making the statement, another example, now I'll be the seller, but I'll do more of a fraudulent misrepresentation. The person making the statement knows it's not true. If I'm selling you the roof and I tell you it's a 30-year-old roof, right? Say I've lived there for 30 years. I know it's a 30-year-old roof, but I tell you it's only a 3-year-old roof. Then at that point, I know I'm lying to you. I know I'm deceiving you and not telling you the truth. And the intention is to lie to you. It is to make you believe it's a great roof. It is to not gear you toward the truth, but gear you toward what I want you to believe, which is obviously in my benefit. So I'm lying to you on a material fact, and I know that I'm lying to you. That's the intent. Now, one of the differences, also, you can also get out of the contract. Of course, you can get out of the contract and not go through with it. But however, that's when the differences comes in. If in damages, what I was the seller would be liable for. They can come back, as I mentioned, as they can get actual damages. They can also get treble damages, so they can get 3 more than the times of than what you actually suffered. Your judge can award you 3 times that amount. So that's the difference. The main difference about what you can recover in an innocent representation or an innocent misrepresentation and a fraudulent misrepresentation is the amount that you can recover is a lot more if you prove that the party who said the incorrect statement, that it was fraud. He knew that he was lying about a material fact. So then the damages would be a lot more. Well, I hope this little table helped and kind of define the differences and what you can recover. But let's go on the next slide and talk a little bit more about this stuff. Now here on slide number 9, still dealing with the misrepresentation. This is more dealing the concealment of a material fact, not just mentioning it, but this time holding it back. Now, although many fraudulent misrepresentation, they arise out of an affirmative promise or a statement of a material fact, sometimes a fraudulent misrepresentation may occur when one party conceals or hides a material fact. So they're not lying to you, but they know it's a material fact and they're trying to hold it back from you. Now, although parties generally, they don't have a general duty to disclose, everything to each other. However, some courts allow the misrepresentation as a valid defense if a party has asserted a half-truth that leads to the overall misrepresentation. So kind of saying halving what's truth, what's not, that may still fall under the misrepresentation. Or one party takes an affirmative action to conceal the truth from the other party, meaning that one party takes it upon himself to do as much as he can or try his best to hide the truth or hide the material fact, then that's also going to fall under misrepresentation. It's necessarily not that that they lied to you, but they did everything they can. They covered it up. They patched it up just to show you that it was okay. So that's still, they didn't tell you the roof was great, but right before you came to see it, they just patched up a big hole that was in there. They didn't even fill it up. They just patched it up. So you saw it and it looked good. So they did a lot. They took an affirmative action. They took, steps to hide that from you. Now, if one party fails to correct a past statement, and the other party later finds out that statement is untrue, then those will fall all under the misrepresentation, and he'll be able to cancel the contract as well. Even when one party does not owe a duty to the other party to disclose the facts that they know, or answer questions about those facts, if they undertake, meaning they start talking about it, then they must do so with with 100% honesty, with the truth. So it's one of those things when they say, you know, if you don't have to talk, don't talk. Then now, if a seller or somebody doesn't have a duty to disclose certain things, but if he voluntarily starts disclosing those things, then he can't pick and choose which one he wants to tell you. He has to tell you the whole truth. So that's just the risk of when you open your mouth and start talking, then you can't pick and choose what you just want to say, holding back the bad stuff. Then you have to say the whole truth, or else it may come back and try to bite you, even to be called a fraudulent misrepresentation, and try to get 3 times the amount of damages. So if you don't need to talk, then I would suggest not. If you don't need to disclose, then don't disclose. That's the rule of thumb for this one. Well, let's go into next slide and keep talking about this. Now here on slide number 10, we're going to deal with additional contract defenses. And so in addition to the misrepresentation, those 5 different types of misrepresentations, the common law recognizes other factors that are that can be used as contract defenses. Now these 3 are going to be duress, undue influence, and unconscionability. Now, although all these contract defenses, they manifest in ways in which genuine assent might be lacking during the formation of the stage. Now, all these are still going to be defenses, these 3, but let's go in the next slide and let's talk about duress, undue influence, and unconscionability a little bit more, so you can get a little deeper understanding of what those contract defenses are. Now, jumping on to slide number 11, duress, which is another way to avoid the contract or make the contract unenforceable. If one party to a contract uses any form of unfair coercion to induce or to make another party enter into a contract or modify a contract, the coerced party or the person who was made to sign the contract may avoid the contract based on this duress, or may have the contract be unenforceable based on duress. Now, generally, the law recognizes 3 different types of duress. One of them is, I think it's obvious one, violence or threat of active violence. I'm sure if someone says, you know, if they go up to you and hey, that pen that you have, I'll give you $1 for it, sell it to me, and you don't want to, and you say, well, I'm gonna physically hurt you, I'm gonna threaten violence on you, then you'll sell it to him, or you'll sign the contract. That's easy to show you were under duress, because I mean you were fearful for physical threat, immediate physical harm to you. So something like that would be obviously that is duress, because you were scared for yourself. Now, second one is economic threats, which are more common, such as a wrongful termination. Now, if, for instance, in this example, if an employee who works for an employer, even though the employer has a right to fire you, because we're in at-will state here in Texas, if the employer says, hey, sell me the stock that you have in the company for $5, or else I'll fire you. Maybe the employee has no choice and they say, well, I don't want to get fired, I have bills to pay. Okay, I'll sell it to you for $5. Even though the employer had the right to do that, the employer was threatening to do something that they had the right to do, but it was still threatening. Maybe that's going to fall under an economic threat, because the employee will say, well, I had no choice because I wanted to keep my job, so I sold it for undervalue. I sold it for $5. Therefore, I was under duress. I should get it back. Now, the third one, or under still an economic threat as well, I wanted to give the example, is a breach of contract, which it's happened before. If say for instance, someone who's remodeling your kitchen is there and it's a big remodel, they're almost done. You're tired. You're the homeowner. You're tired of all this construction all the time in your house. They're going to do the last thing. But say for instance, you owe them $1,000 for them to do the final and last thing. If they come up to you and say, hey, that last thing, I'll do it, but you owe me $5,000 to do it. And you may say, I thought we were already in agreement. All the contract is already lined up. We signed the contract months ago, and it said this last stage that you were gonna finish. I only owe you $1,000 for it. And they may say, yeah, but then I'm gonna threat to breach I'm gonna threat to walk away. The contractor may say, I'm gonna walk away if you don't give me $5,000. So maybe at that point you're so tired, you don't know who else is going to come just to finish that part. So you may pay $5,000 just to get it done. At that point, that's an economic threat. You were still under duress to sign that contract because you really had no other choice but to pay him $5,000. So that would fall under duress. Now the third one, of course, is threats of extortion, or other threats where the other party has no meaningful choice, where you can show from a subjective point, you can show the court or the judge that you had no choice. You really didn't have a bargaining power. You kind of were stuck and you had no choice but to comply or to agree to the contract. Then that's generally going to fall under duress and allow the party signing the contract, or the party that had no choice but to sign the contract, allow them for a way to have the contract be unenforceable, and also try to get their money back or their damages or whatever they did, try to get that back because they signed under duress. Well, let's jump on to the next slide, talk about the next element. Now going on slide number 12, another contract defense is the undue influence. Now, undue influence is a defense that gives legal relief to a party who has been induced, or we call it forced, to enter into a contract through improper pressure of a trusted relationship with an individual. Now, undue influence allows the influenced party, the person who signed, to avoid a contract when the court determines that the terms of the contract, that they're just unfair, and that second, that the party involved or the person who made the other person sign had some sort of fiduciary duty or some sort of duty of care to that person or to the influenced party. A great example of this is, for instance, a caregiver. If a caregiver is giving care to an elderly individual, and the caregiver says to the elderly individual, okay, you need to sign this contract that you're going to give me $50,000 worth of your Microsoft shares, or I'm going to leave. Then that elderly individual may be scared. Doesn't know how to find, doesn't know what else to do. How do I find another caregiver? I'm at a vulnerable situation, and that caregiver has a fiduciary duty or a duty of care to that older individual. So that older individual signs that contract to transfer $50,000 worth of Microsoft shares. The court will most likely find that contract unenforceable due to undue influence. Basically, it was unfair, you were taking advantage, and you had a duty of care to that person. You had some sort of responsibility, and you used that person, you took advantage because of your position. So then that's going to fall under the undue influence. So let's talk a little bit more on the next one. Now, on to slide number 13, the unconscious ability. Now, the defense of unconscious ability gives the court the tools to refuse to enforce the contract where the consideration is grossly unequal. The court mentioned it where the contract just shocks the conscience. Now, I know previously I mentioned where there's consideration. Now, consideration, if you remember from the prior slides or videos, consideration is where both parties get something of benefit, but both parties also get a detriment, a burden. Then that's consideration. One party gives up something but gets something. The other person also gives something up but gets something. Now, the courts generally will not look at who got a better deal. Well, you gave up very little and you got a lot, and you gave up a lot but got very little. The contract was very unbalanced. So one party is a great bargainer or a great deal maker, and the other one's not. Now, the court generally will uphold those terms, and they're not going to say, no, well, if you purchased a property, you should have paid more, so therefore it was grossly unequal. Now, no, they won't say that. As long as there's adequate, reasonable, minimal consideration, they're going to uphold it. But there are times, although it's difficult to argue, that there's unconscious ability. For example, in their book gives an example. There was a woman who sold her annuity. Now, an annuity has a lump sum value, where they can give you the money, they can give it to you right now, and had a lump sum value of $150,000. So she can sign a paper that day and the next day get $150,000, or she could get payments throughout the years and it's going to equal over $500,000. but she would have to wait. It doesn't mention how many years, but she would have to wait years to in total get that 500,000. Now, knowing that she could immediately sell that for, tell the insurance company, no, I don't want the payments, just give me the one lump sum. That one lump sum was worth 150,000. So the court considered it grossly unequal because she sold that contract that day for, I believe it was somewhere under $50,000. So the court was just there, scratching their head and thinking that that's just grossly unequal. It's they also, I think she was on a drug addiction and things like that. So they considered those facts, but they say, you were mentioning when it's you could very easily get the face value for 150,000 the next day, but you sold it for 50,000. That kind of just shocked the conscience, and they believed that was grossly unequal. So they held that contract to be unconscionable and unenforceable. So in that case, I know I mentioned previously that courts won't consider the consideration. They won't look into that, but if they believe it's grossly unequal, they may sometimes step in and say that consideration is invalid, it's grossly unequal, so it's unconscionable, and the person who wants to get out of the contract, they will have a valid defense. Okay, well, let's go on to the next line and keep talking about this. Jumping on here to slide number 14, we're going to discuss the statute of frauds. Now, the statute of frauds, it's going to refer to a law in each state that governs which contracts must be in writing to be enforceable. So again, there's the statute of frauds requires certain agreements or certain contracts that then must be in writing, or else it's unenforceable. Now, the main purpose of the statute of frauds is like it sounds, or it's to prevent frauds, to prevent fraud from happening by requiring that certain type of contracts have written evidence of their existence and their terms. So again, written evidence of their existence and their terms. Now, the next slide, we're going to go over what type of contract there must be. But essentially, again, in each state, there are certain contracts that require that agreement, whatever you're agreeing to, it must be in writing. It cannot be verbal. So then, so that there's evidence of the existence of that agreement and the terms of that agreement. So let's go on the next slide and let's talk about which type of agreements need to be in writing. So there needs to be written evidence on that. I'm jumping on here to slide number 15. Still sticking with the statute of frauds. Again, we mentioned the statute of frauds is by every state. It requires that certain contracts or certain agreements be in writing to have written evidence of their existence and their terms. Now, this slide is going to show the 6 type of contracts that must be in writing for it to be enforceable. Now, first one are contracts that involve the sale or the use of land. If you're selling or transferring property or selling land, the contract must be written. Verbal contracts will not suffice, will not be sufficient to show that there is agreement for the sale of land. Now, the second one is contracts that cannot be performed in under 1 year. So by their terms, if there's a service contract that I agree to be your IT provider, I agree to revamp all your data, all your storage, revamp your website, everything that I want to do will take longer than 1 year. If all my services are going to take in total longer than 1 year to complete, then that contract must be in writing. There must be evidence on there. Now, a third one is contracts to pay the debt of another. An example is a loan surety that they're guaranteeing that if the debt isn't paid, then I will fill in and I will pay that debt for that individual. That needs to be in writing. The lender cannot go after that person that says, like, I'll pay it if Robert doesn't pay it, then I'll pay it. Then the second person, they're not going to go after that second person as if it's not in writing. So those contracts have to be in writing. Now, other fourth ones is contracts made in consideration of marriage. So anything dealing with your spouse that revolves an agreement with your spouse. For an example, a prenup or a postnup. Those things, they must be in writing. Fifth one are contracts by the executor of the will, the person who is probating the will, an agreement for the executor to pay the debts of the estate with his or her own money, then that's something that that needs to be in writing. Now, the final and sixth one are contracts for the sale of goods that are going to be over $500, and the lease of transactions for goods amounting for more than $1,000. So the sale of goods over 500, and the lease of transaction of goods for $1,000 or more. So now those 6 types of agreements, they must be written. Those agreements cannot be verbal, or else they may be held in court to be unenforceable. Because with the statute of frauds, these type of agreements in the states, they need to be in written to show evidence of the terms and the actual agreement. Let's go on to the next slide and continue with this. Now here on slide number 16, the contract interpretation and the parole evidence rule. Now the parole evidence rule states that any written document or intended by the parties to be the final expression of their agreement may not be contradicted by any oral or written agreements made prior to them in writing. Say for instance, if we're going back and forth and discussing an agreement in email, right? In an email back and forth, I want this, I want that. We're negotiating an email, and then at the end, then we enter into a binding contract, the agreement, which it's signed, it's long, it's lengthy, and we actually sign it. Now, what the parole evidence rule is saying, hey, in an email prior, you stated that you were going to do X, Y, Z, but in the contract, you only stated that you were going to do X, Y. So the parole evidence rule said, no, that's the final agreement. Any agreements, discussion, communication, written or verbal, done before the actual final agreement, it cannot be binding anymore. This was just negotiation. It can't be used anymore to say, well, in that final contract, prior you sent an email that you said you're going to do a lot more. However, in the contract, you state you're going to do very little. Then the contract is binding, that's final. It doesn't matter what was going back and forth before. The parole evidence rule says what the final expression, the final written contract, that's the final verbiage that we use. However, the parole evidence rule does not bar admission of preliminary documents when they are being used to determine the meaning of the party's intended concern for a particular term in the contract. So again, same example, so we're going back and forth, we're sending several emails with each other, discussing terms, negotiating, and then we enter into a final contract. So the parole evidence rule says you can't use any of those preliminary documents or communication and as binding on the contract. However, the courts will allow if during the contract there was a term that we didn't know how to what it means, or we're now that we're signing and we're litigating or we're in court, it's kind of not clear. We can use prior emails or prior communication to justify, to show what our intent was in that contract, not to contradict it, not to change it, but just kind of to clear up what we meant in that final contract, because we had several discussions before, Your Honor. Here are all the emails where we can maybe clarify what we meant in that final contract. So that's the parole evidence rule. But let's jump into to one more slide to discuss this. We're almost done, guys. Jumping on to slide number 17. So this is the last slide that has subject matter in it. So we're almost there. We're in the finish line. Other rules of contract interpretation. Now, in cases involving ambiguous terms that are not clear, terms that they're not definite, we don't really understand what they mean, the terms are construed by the court against the party of the side that drafted the agreement. So this is very important when hiring an attorney. If you're drafting, I'm drafting an agreement for a client of mine, if the term is ambiguous and the court isn't sure what I meant or what who it benefits, they will construe that concept or think of that against me. So I have to be very sure when I'm drafting the contract to not leave any ambiguous terms, because they will be used against me. If it's unclear, it's going to be for the benefit of the other side, because they were not the ones who drafted the contract. I had the power, I had the ability to draft the contract, therefore it's my fault that I left it ambiguous. Therefore, that ambiguous term is going to fall in favor of the other party. So just be sure when hiring an attorney that attorney knows that any ambiguous term will be used against them. Now, the courts may also apply a reasonable term in a situation where perhaps maybe they left something out or it's silent in that matter. Then the term will generally fill in their own term of what the parties probably meant in a reasonable matter. So that's the way the court will interpret it certain when it's silent on those documents. Well, thank you guys. This is the last slide on this one. Let's just jump into the final slide for some ending comments. Well, thank you guys. This is the final slide, slide 18. Thank you for joining me again. Again, we just discussed chapter 10, which is our week 6. Next week we'll be going into chapter 11, performance, and which will be week 7. Again, if you guys have any questions, you all know how to reach me. Please read the chapter. Read the chapter before seeing the video. I think it would be great beneficial if you guys do that. But thank you so much for joining me. Again, next week will be week 7. We're going to discuss chapter 11, performance. Thanks a lot, guys, and see you later.